All right, so again, welcome everybody. This is going to be a 90-minute presentation on extreme risk protection order essentials for gun violence prevention. Appreciate everybody being here this morning. I'm going to start with a little bit of an introduction. My name is Christopher Carita. I'm a retired detective. I was a former hostage negotiator and detective specializing in threats of mass gun violence and using risk protection orders here in South Florida. I'm a national expert in violence prevention, behavioral threat assessment, and extreme risk protection order implementation. I earned my Master of Public Health at Johns Hopkins University as a Bloomberg American Health Initiative Fellow, and my focus was on violence prevention as a public health issue. So learning how to take the big data and turn it into workable policy. I'm also an author and presenter on IRPO for the International Association of Chiefs of Police. I'm a contributor to the national guidelines put out by Johns Hopkins on IRPO policy and implementation. I'm a former master trainer with the Department of Homeland Security's National Threat Assessment and Reporting Program, and I'm currently the Senior Training Specialist and Law Enforcement Advisor with 97%. So just a little bit of what to expect today. We're going to spend about 90 minutes together. Again, this is going to be a recorded presentation. Once we get to the end of the presentation, I'm going to stop the recording and open up for questions. We're going to go over the essentials for effective use of extreme risk protection orders. That's going to mean walking through the process. We're going to describe 4 case examples and talk about how IRPO fills the gap in those situations. That's going to include suicidal threats, domestic violence, school shooting threats, and other situations of community violence. We're going to learn about other trainings being offered by 97%, and then we're going to have time at the end for questions. And again, that'll be off camera. So just to start, I want to talk a little bit about who is 97%. So 97% is a nonprofit organization with the mission of reducing gun deaths by including gun owners in the solutions. They've been around for about 5 years, and there's a strong focus on bringing gun owners into the conversation and working on the policies that they agree on, and also working with gun owners to identify the issues in current policies that are a sticking point that can be solved. Extreme risk protection orders are amongst those policies that we focus on. In recent surveys over the last 4 years, consistently between 70 and 80% of gun owners agree in concept that a risk protection order is a good idea. And the reason we're focusing on these trainings is to make sure that law enforcement understands the concerns of folks when they're in a crisis and their firearms may need to be removed for their safety and for the safety of the public, at least temporarily. And so that we understand their concerns and we can incorporate that into how we implement these laws. So again, with that, over the last year, we've had a focus on providing IRPO training and support with course offerings and policy workshops at 97%. So let's go right into it. This is going to be a pretty straightforward, condensed version of IRPO essentials. So we're going to go through the process, and we're going to start with kind of an overview of what is an extreme risk protection order. Most of the people in this room have an understanding of how they work, so we're not going to belabor that, and then we'll get right into the process. So just to put into context, an extreme risk protection order at its core is a valuable legal tool. An extreme risk protection order, as it's most commonly known, is a court order that temporarily prevents someone who poses a significant danger to themselves or others from possessing or purchasing firearms, and in most states, ammunition as well. So why is it a valuable tool? Well, it fills a dangerous gap in our other tools. We, as law enforcement, have all had those calls, especially early on in our career, where you show up, you see all of this dangerous behavior, you see all of the signs and all of the elements that this situation is going to get worse, and yet you don't have probable cause for an arrest, you don't have the elements to do an involuntary commitment. You don't have what you need to step in and to create any additional safety. And you're unfortunately walking out of there with the knowledge that you're going to be back and it's probably going to get worse before you can help make it better. Well, ERPO is a tool that can help with a lot of those situations, especially when a firearm is involved. So you're going to have situations as law enforcement where you regularly encounter individuals that exhibit dangerous, concerning behavior, yet they don't meet the criteria for your normal interventions. ERPO helps create time and space between somebody in crisis and firearms, which are the most accessible and efficient way to do damage that we have. So by creating time and space between somebody and their firearms, you're giving them the opportunity to get the help they need, and you're creating safety for their family, for their community, or for whoever it is that they may be threatening at that point. The other really important thing to keep in mind with ERPO is it's a shift for law enforcement to true prevention over enforcement. There have been a lot of pushes for preventative policing, proactive policing, but in reality, all those forms of policing are still responding to data and reallocating resources. We're still reacting after something has already happened because there's a good chance that it will happen again there. Well, ERPO gives us an opportunity to remove firearms from a bad situation and hopefully prevent the worst possible outcomes and save lives. So what does ERPO adoption look like in the United States up until now? Well, the first ERPO law was actually a risk warrant, and it was passed in 1999 in Connecticut after the famous lottery shooting. I'm not, I think a lot of the people in the room here are old enough to remember that, but it made national news, and it was a workplace violence situation. It was an act of targeted violence. An employee came to the Connecticut lottery and did a lot of damage. Well, Connecticut responded by creating a risk warrant. It was originally based on the legal framework of an arrest warrant or a search warrant. You had to have a pretty high threshold to get a risk warrant. You had to have proof that the person already had possession of a firearm, and it was limited to law enforcement use only. But it was the start. It was the start of starting to think about what can we do to prevent these tragedies. What legal tool, what legal grounds do we have to step in to say that this person at this particular moment needs to be separated from firearms so that we can put other interventions in place. 6 years later, in 2005, Indiana had a shooting. Officer Jake Laird lost his life during a traffic stop. He was shot and killed by a subject who legally should not have been in possession of firearms due to mental health holds. However, there was no mechanism in the law once somebody was adjudicated mentally ill to actually go remove those firearms. So Indiana took the step of passing a law very similar to Connecticut's. Again, it was a risk warrant based on the criminal process. Very high thresholds and law enforcement use only. Then in 2012, we had the Sandy Hook shooting in Connecticut, and the Consortium for Risk-Based Firearm Policy was brought together. It was a group of gun violence researchers, psychologists, psychiatrists, and attorneys who got together and said there has to be a better way, a more effective way for us to intervene early and prevent these tragedies from happening. We keep hearing that there are all these precursor behaviors that lead up to these tragedies, whether it's a suicide or a mass shooting. There has to be something we can do. And so they looked at what was already on the books, and domestic violence restraining orders had been in existence in the United States since the 1970s and existed in every state since the 1990s. So they looked at the framework and they developed what we now understand as an extreme risk protection order, which is a civil order to temporarily remove firearms from somebody when they're in crisis. The first state to pass the new version, this civil version of the extreme risk protection order, was California, and that was after the Isla Vista shootings, and that was Elliot Rodgers, the famous incel, for those who are familiar, who targeted sorority members outside of their sorority houses in the Isla Vista area of California. Further tragedy Here in Florida in 2018, we had the Marjorie Stoneman Douglas shooting, which was the impetus for us passing our RPO law. Between 2018 and 2023, additional states got on that bandwagon. 16 additional states in the District of Columbia also passed ERPO laws. By 2023, more than half of the US population was covered by an ERPO law in their state. And today, in 2025, ERPO laws are in effect in 21 states, the US Virgin Islands, and the District of Columbia. And I should also note the Connecticut law has been updated since the original impetus. They have created mechanisms for certain family members and psychiatrists or psychologists, clinicians, to formally request through the courts that an ERPO be investigated. So even Connecticut has updated their law to mirror more of what the modern ERPO law is now. So what is the purpose of ERPO? It's a temporary civil tool. It's designed to reduce the immediate risk. It's designed to turn the temperature down, create time and space between a person in crisis and their firearms. It's behavior-based. It's not diagnosis-based. This is an important distinction. There are mental health holds, and there are mechanisms in almost every state for somebody to be adjudicated mentally ill, adjudicated to where they won't be legally allowed to possess firearms due to their mental illness. But that is an extremely cumbersome process that can take time and that leaves people at risk. And the Jake Laird shooting in Indiana is an excellent example of that, where those mental health laws fall short of taking the extra step of removing firearms when those cases come to light. With that, we will see how ERPO actually complements criminal and mental health tools, but it doesn't replace them. ERPOs are for one thing and one thing only. It's when a firearm is present in a dangerous situation and we need to create space between a person and their firearms. That's it. It doesn't restrain the person's movements. It doesn't prevent them from continuing their job. There's no form of arrest or detainment. It is simply targeted at removing firearms temporarily while a crisis is imminent. And again, with that, it's important to understand that ERPO is not designed to be punitive. It's designed to be preventative. Now, I say that, but we should keep in mind that there are many individuals in this country who are not going to feel very good about us having to remove firearms when they're in crisis. They're actually going to feel very much like this is punitive. So as we go through these scenarios, we're going to talk about and we're going to touch on places where you can help build a rapport and you can help the person understand, the subject of these orders, understand why this order is necessary and help them to get through this while maintaining their dignity, while connecting them to the services that they need, and doing it with as much compliance and cooperation as humanly possible. So what are the key risk-based criteria often cited in ERPO statutes? Every statute has slight variation from state to state. Most states articulate between 12 and 15 specific behaviors and criteria that can be considered by the court. Why is that important? Well, it's important because there's a difference between feeling threatened and being threatened. There's a difference between feeling that someone is at risk and someone actually being at risk. And when you look at these statutes, the criteria that is listed in the statute is very specific and it is linked to elevated risk. So things like threats or acts of violence. There are reams of research that show that when somebody is engaging in acts or threats of violence, they are much more likely to continue with those acts of violence. They are at higher risk for continued violence. If they engage in dangerous behaviors with a firearm, right? If they start behaving recklessly or waving it around, making veiled threats while displaying their firearms, these are again indicative that the risk of violence has escalated. If someone has recently acquired firearms, that can be an indication that somebody is at elevated risk. But there's caveats to that, and there's caveats to all of these, and we'll get to that in just a second. If there's a history of serious mental health concerns, now again, This doesn't mean that if somebody has a mental health diagnosis, they are prohibited from having firearms. That would prohibit probably more than half the country at this point if the statistics are to be trusted. What this means is you should consider someone's mental health when that mental health or mental illness is an exacerbating factor to violent behavior. In other words, if somebody is diagnosed as schizophrenic, but they take their medication, they manage their symptoms, they are functioning, and everything is good in their life, then the fact that they have a diagnosis is not grounds for filing for an extreme risk protection order. However, if somebody is a diagnosed schizophrenic and they are not managing their symptoms and they believe that little green men are coming through their walls and they have a firearm and they're ready to shoot those green men and put their neighbors and their family at risk, that is a very different situation. So it's important to link these mental health concerns directly with the dangerous behaviors. Along with that is substance use that impairs judgment. This is important, especially in states that have legalized marijuana. We can't punish somebody with an extreme risk protection order for exercising a right or an activity that they're legally allowed to engage in. However, if somebody is using marijuana while using their firearms and it's affecting their judgment, the same is true of alcohol, which has a much stronger link to violence. Alcohol, cocaine, whatever the substance is, if it is leading them or affecting their judgment and a contributing factor to their violent behavior, that's something that gets considered in these statutes. Along with that are violations of existing court orders. So if you already have a domestic violence order in place, a stalking order in place that didn't already prohibit them from having firearms, or if you have a situation where the person is continuing to violate those orders and we need to take additional steps as law enforcement to own that petition and to own that enforcement, then those violations of previous court orders may be a reason to escalate and utilize an extreme risk protection order and take the additional step of physically going to remove firearms from that situation. Now, I said as we went through these that there's a caveat to this and to all of these. It's important to understand context, right? So dangerous behavior with a firearm, and one of the behaviors I cited was displaying a firearm and making a threat. Well, if somebody is approached on the street and is threatened with a knife, if their life is put in danger and they display their firearm and they use a firearm in legal defense of themselves, then that is not dangerous behavior with a firearm. That is a legal defense of their own life. And that's not a behavior that we're going to link to an extreme risk protection order. Even threats or acts of violence. If that same situation, if somebody's life is being threatened and they draw a firearm and they say, if you don't get back, I'm going to shoot you in the face, right? That's pretty horrific. But they may legally be allowed to make that threat to protect their own life. So it's important with any of these behaviors to do a good investigation and to have context for why they engage in the behaviors. Recent acquisition of firearms is an excellent example. You are legally allowed to buy firearms in the United States, and in most states, there is no limit to how many firearms you can buy in a single acquisition. There's nothing wrong with that. However, if somebody has a stated grievance with their boss at work and they're escalating in their violent rhetoric, and now somebody who has never owned a firearm in their lives decides to go and start a collection, that may be something that we want to consider in the totality of the circumstances if we're petitioning for an extreme risk protection order. So this is extremely important. I want to talk a little bit about the due process that's built into the extreme risk protection order process. So ERPO has procedural safeguards built right into the statute in every state that has passed these laws. To file a petition, you have to meet the statutory standards that are in your state statute, and it has to be evidence-based. We talk a lot in threat assessment about the difference between feeling threatened and being threatened. We can't move forward with an extreme risk protection order because of a feeling, because we feel that somebody is dangerous or because somebody else feels threatened. We need evidence. We need concrete behaviors linked directly to the statute to move forward with an extreme risk protection order. Without those articulable, documentable behaviors and evidence, we don't have a case, and we should not be moving forward with a petition. Also built in is judicial review. The first firearm cannot be removed until a judge has reviewed your petition and granted your order. Police officers cannot remove firearms for an extreme risk protection order until it has been reviewed and approved by a judge. That is the executive branch being checked by the judicial branch, and that's exactly the way things should work. And that's how they work with domestic orders and any other civil order that is available to law enforcement. Along with that, the respondent has the right to a hearing within a required statutory timeline. In most states, that's 2 to 3 weeks maximum. That means from the time that they are served with the initial order and firearms are removed, they have a court date usually within 14 days, and they have an opportunity to present their case and to defend their right to retain their firearms. So that presents a clear opportunity to contest the allegations. Along with that, the onus for presenting evidence is on the petitioner. So if you are the law enforcement officer who is presenting a petition, you have the burden of proof. If they stay silent and you don't have the evidence that meets the statutory criteria, if you don't have a sufficient case, the respondent does not have to defend the case. The burden is on you as the petitioner to make the case to the judge that an ERPO is needed. The orders are also temporary and time limited and extremely narrow in their focus. So they are focused on temporary firearm removal. In most states, that's 6 months to a year, maximum of a year. And there is opportunity during the course of while that ERPO is in effect, there is an opportunity for the person to appeal or to request an early termination. Every law in the country has that built right into the statute. And finally, the firearm return is automatic at the end of the ERPO. When the ERPO expires, whether it's law enforcement who has the firearms in their possession or a third party that's allowed by that particular state, the firearms must be returned to the owner at the conclusion of the extreme risk protection order. Plain and simple. The respondent does not have any responsibility to take any further action to have their rights restored. So why is due process so important? Well, when we follow our statute and we follow the due process protections that are built into the ERPO statute, we ensure that our use of ERPO is fair. We ensure transparency, right? So we have at least 2 court hearings that become a matter of record. Depending on your state, most states it's not public record. You have to have certain access. That's to protect the respondent's. Protect the respondent's privacy. However, the respondent has a right to all evidence and to all records related to their case before their final hearing and post-hearing, right? And what does that do? Transparency builds public trust in our use of this tool. It ensures that when we are removing firearms, we're removing them lawfully, only after there's been judicial oversight, only after there's been judicial approval, or we have permission from the owner of those firearms. Due process also protects the respondent's rights. It ensures that we are following their Fourth and 14th Amendment rights. It also ensures that if we follow the due process protections that are built into the statute, we're ensuring that each time we get one of these orders, it is a strong, enforceable order, meaning that we are on solid legal ground and we are not opening ourselves up to liability. Also, when we follow the statute, we are making sure that we are maintaining the credibility of this tool and of the whole and of this system. If we find ourselves stretching to use an ERPO, stretching a case to because we don't know what else to do, and we stretch ourselves to use an ERPO or we use political reasons or other bias and concerns start to infiltrate our cases, we lose our credibility and we lose our ability to keep ourselves safe, and we lose our ability to use this tool. So again, that brings us to the flip side. What happens if you don't follow the due process procedures in the statute? Well, your case is going to be dismissed. You're risking civil rights violations. You're risking loss of community trust. You're opening up your agency and yourself to legal liability. And depending on your state, there are some pretty hefty penalties for unlawful or dishonest use of extreme risk protection orders. Obviously, any weapons that were retained are going to be returned immediately once it's found that the ERPO does not have grounds to stand, which means if you didn't do a good job, if you didn't follow procedures, now you've recreated that dangerous situation that you were looking to de-escalate, and more than likely you've now escalated things. You've now turned up the temperature. Also, you end up with weakened protection for the victims and the public, and you risk misuse of the ERPO process overall, which ultimately could result in us losing this extremely valuable tool. So let's just briefly go over the ERPO process from start to finish. This is a very simplified version. But it's really important to understand that it is actually this straightforward. It's no more difficult than most of the legal processes that law enforcement engage in, whether that's arrest or involuntary commitment. There's a procedure, and we should follow it. So we start off with our incident of concern. All right, where law enforcement responds to the scene, or we receive a call. We conduct our investigation and begin to gather evidence. We want that evidence that we're gathering to reflect specifically what we see in the ERPO statute. Once we've gathered that evidence, if we've determined that an ERPO is needed, we're going to file the petition. Then we move to our first round of judicial review. Typically, when we file an ERPO, the majority start with a temporary order. In most states, this is the way it's structured. You start with a temporary order that's initially served. So during your first review, the judge is going to review the evidence that you present as the petitioner, and they're going to make a decision. If they decide that you've presented adequate evidence for the temporary order, they're going to issue the order. Now you have the responsibility of making sure that order is served. Again, some states separate this, where the law enforcement agency who files the petition may be one agency, but then it goes to the sheriff's office or another agency, a larger agency to serve. But for the most part, the same agency that obtained the order is going to be the one serving the order. So now it's time for safety planning, and it's time to serve the order and remove any firearms that may still be in the possession of the respondent. Then within 2 weeks, you have your final hearing. The judge hears all of the evidence that you present. The judge hears from the respondent, and the respondent has an opportunity to say why he believes that everything you're saying is nonsense. And then we have a final decision from the judge. So if the judge decides to grant the final risk protection order, it can last 6 months to a year. At the end of that 6 months to a year, you have a decision to make. You would follow up on the case. You would determine whether or not the initial crisis that brought this case to you in the first place has been resolved, and if there's evidence that this person is still a danger to themselves or others. In more cases than not, for us, the vast majority, after a year, the person has been connected with services, has gotten the help they need, has gotten past their crisis. Maybe they have a new job and things are good. And we have no new evidence to say that this person is still a danger to themselves or others. So in that case, the order expires on the predetermined date, and firearms are returned at the time that the order expires. In most states, law enforcement also has an obligation to inform the respondent that the order has expired and that it is time for them to come retrieve their firearms.
Has he said anything important yet?
No.
Oh, I froze up.
Oh, did I?
Someone unmute. No, the important stuff is coming. So walk through the ERPO process. You have your initial investigation, right? You receive your credible concern. You start to gather evidence of the facts. During this process, you also want to identify if this person has access to firearms. That's an important factor if you're deciding whether or not to use an ERPO. If there's no nexus to firearms, an ERPO really is not something that we should be considering. We should be looking at other tools to mitigate whatever threats or concerns arise during the investigation. You want to note, so when I say note these behaviors suggesting elevated risk, that means we're documenting everything. We're documenting it in our police report. We're documenting it through our normal evidence procedures. If there are threats on a phone, we want to be grabbing screenshots. We want our officers who first respond to these scenes to treat this like any other investigation. An ERPO requires evidence to prove elevated risk. If we don't treat it like a legitimate investigation, we are not going to have the evidence that we need to move forward with an ERPO if one is necessary. So then we move on to petition preparation. So you want to confirm that you can actually file in your state. For all of us that are law enforcement, that's every state that has an ERPO law. If we have any clinicians or educators on the call today, you want to make sure that in your state you can be the one to petition. I would also say that as clinicians or educators or folks outside of law enforcement who can legally petition the court for an ERPO, I would advise you to consider contacting your local law enforcement agency to investigate the case and possibly take the lead on the ERPO for a number of reasons. One is your own safety. If you're dealing with someone who's in crisis and they have possession of a firearm, it puts you in a position where you're now conducting an investigation outside of the purview of your skill set and of your normal work. However, there are going to be situations where getting law enforcement involved early may escalate the situation, and you as a clinician or an educator want to move forward. Just make sure in your state that you can be the one to move forward with the ERPO. In that petition, you want to summarize the evidence clearly. You want to link it back to statutory language. So what does that mean? Well, it means pulling out the statute, right? We do this when we make arrests. I remember early on, we'd have our big statute book next to us while we're filling out a probable cause affidavit to make sure that the language we're using in our PC was in line with the statutory language. You want to do the same thing with an ERPO. You want to have the statute out. You want to make sure that you're articulating these behaviors in the same terminology that is in the statute to make it clear to the judge and to check yourself to make sure that you actually have what you think you have. And then you're going to file the petition with any required forms or attachments. This is something that keeps coming up in our trainings. Legally, all you need to do is file the sworn petition or affidavit. But if you, at the very beginning, have already collected evidence that's important, that's a photocopy of a threat that was posted online, if you already have medical records or reports from other agencies, if you already have documentation that this person is an escalating risk of ongoing violence, there's nothing wrong with including that with the initial petition. And that goes a long way for judges getting the full picture and understanding why you're taking this step of trying to remove firearms from the situation. At this point, we have judicial review. So the judge evaluates the evidence. They may issue the temporary order. And at this point, they set the hearing date. Now, these orders are time limited. Now, I say they set the hearing date. At this point, in most cases where you've filed for an ERPO, you're doing this within a 24 to 48 hour period just after the incident that brought you to this case, right? So you've had to do an enormous amount of investigating and research in a very short period of time. I implore you all to use that 2 weeks from the time that the hearing is set, then you get the temporary order to the final hearing, to continue your investigation. And one of two things is going to happen. You're going to find additional evidence that supports your claim, or you may find evidence that balances out and that gives greater context to the situation. Either way, when you show up at court for the final hearing, you want as full of a picture of what's going on as humanly possible. So then we have service and firearm dispossession. So just like any time you're going to a house that you know has firearms in it, and especially in a situation where you've already determined that this person is at elevated risk, you want pre-service safety planning, just like you would for a search warrant or an arrest warrant at someone's home. You want to plan and you want to have the personnel you need. Now, if you've done a good job, if you've already spoken to the respondent, you responded after the initial investigation, you've built a rapport, and in many cases, you may have already spoken to the respondent and gotten compliance where they've already voluntarily surrendered their firearms because they understand, yes, they're in crisis and they're willing to comply. Then service becomes a formality, and because you've already alleviated the risk. But every single case is different. You need to plan for what the situation in front of you is, and you need to make sure you have the personnel and the resources available when you serve these orders. Once your job then is to remove any firearms that are at the home, depending on your state. There's an opportunity for the respondent to voluntarily surrender any additional firearms. In some states, you're forced to file a search warrant along with the extreme risk protection order. My advice would be, even in those situations, serve the ERPO, serve the search warrant, and still allow the respondent the opportunity to comply and cooperate. This is going to help maintain their dignity. This is going to help maintain a calm situation. You're less likely to escalate, as opposed to, treating this like any other criminal situation. You want to be as respectful as they allow you to be, and you want to gain compliance on these calls, because that's really what's going to keep you safe and what's going to keep them safe while you're executing these orders. Once you've served, then you're going to have the final hearing. The respondent here has the opportunity to be heard. The judge evaluates the totality of the evidence. The court may grant or extend or modify the ERPO, and the order remains time limited. So again, each state is limited to 6 months to a year. I think almost across the board. The other thing to keep in mind at this hearing is this is really where there's an opportunity for the judge to mandate or to offer services. So this is something you may want to build into what you ask for in your final hearing. Each state is different in what the judge can and can't order or can and can't require. Some states allow for a mental health evaluation or connection to services. Some states allow for the court to impose certain conditions while the order is in place. But for the most part, the order is narrowly focused on removing the firearm from a dangerous situation. But anything you can do in that final hearing that's going to mitigate the need for you to renew this order a year later is going to save you time. It's going to create more safety, and it's going to negate the necessity for you to carry these cases year upon year. And then finally, we have expiration and firearm return. The order ends at the statutory expiration. The firearms are returned following those court procedures, and documentation is going to confirm compliance and eligibility. What does that mean? That means we still want to follow our procedures for returning firearms. During the course of that year, this person may have been involuntarily committed. They may have something now on their record that, separate from the ERPO, prohibits them from possessing firearms. So when the order expires, you still have an obligation to run your normal background checks like you would any time you return a firearm for any other situation, and be sure that the person is still eligible to possess firearms, right? That's going to cover your liability. You don't want to be on the news for having handed a firearm back to somebody who should not have had them in the first place. So almost every agency has these procedures in place already, and ERPO, being the reason that you have these firearms, doesn't change your procedures. Make sure you follow your evidentiary procedures, and make sure you're confirming that somebody is eligible to have their firearms back. So let's talk about some case examples, some of the most common use examples for ERPO that we've seen so far. So the first is actually suicidal threats. Even though the majority of ERPO laws have passed in the wake of major tragedies and mass shootings, what we find time and again is that suicidal threats are actually the most common use for ERPO. The reason is we see behaviors. Usually when somebody is suicidal, there are signs, and there are family around who are able to see those behaviors and they're able to reach out for help and get the ball rolling. So what are some of the indicators? Well, very often there's a recent or significant stressor or loss in their life. They make they have verbal or behavioral cues indicating self-harm risk. They have access to firearms, or have even indicated their willingness to use firearms on themselves. And they have noticeable behavioral decline or changes. So, this could be a mom calling that her son is, despondent, has been making veiled threats to harm himself, that he doesn't want to live anymore, recently acquired a firearm. Very often, more often than not, these are not situations where there's an arrest. There's no arrestable offense, and threatening to harm yourself is not a crime in any state. In many cases, there may not even be enough for an involuntary mental health hold. Often when you have ongoing suicidal threats, it may be stale by the time you get it. So you may not get the call till the next day. And now you make contact, and the person doesn't say the things they need us to say for us to move forward with an involuntary commitment. But we still have witness accounts. We still have text messages threatening to harm themselves. We still have evidence that they have access to firearms. We show that there's an escalation in those threats over a period of time. This may still be a situation where we want to use an ERPO. Additionally, it's important to understand what your state's process is for firearm removal when there's an involuntary commitment. In Florida, if you're Baker acted, if you are involuntarily committed by the police to the hospital, that in and of itself does not create a restriction on your access to firearms. In fact, even if you're admitted to the hospital for that mental health situation, that does not preclude your ability to possess firearms. It has to go so far that the doctor files another specific form with the state to request that your access to firearms be removed for that to actually be initiated in the state of Florida. And from my research, it's very similarly cumbersome in other states. It's important to understand that. So you have somebody who's at the hospital, maybe they get there, they say all the right things, they get it together for long enough to get discharged. Now they still have a firearm at home. We don't have a legal reason to have removed them in the first place. This is where ERPO is extremely important. And it's important to understand that ERPO and an involuntary commitment are often very well paired together. And serving the person while they're in the hospital for that temporary period of time and getting the firearms out of the home before they return home is an excellent practice and should be our goal when we have these situations. And again, it fits a suicidal situation. Suicidal ideation peaks and valleys, right? We have situations where somebody is feeling good and then they drop off very quickly. Everyone's mental health can be affected by outside reasons. They can be affected by our own chemistry, but it's peaks and valleys, right? And when someone is in that valley, they're not going to stay there forever. But while they're in that valley, it is important to take any steps we can to protect them from harming themselves or potentially harming someone else in the process. Okay, I want to talk a little bit about domestic violence related risk. And with this, there's a particular case that I think is important to highlight. I had a call where we had a woman who called in. Her husband was extremely emotional. He was upset about some issues that he was having with his own business. Things were not going well, and he started making veiled threats that he was going to harm himself. At one point, grabbing a firearm from a drawer in front of his 10 and 8-year-old daughter and his wife, and yelling to them that they didn't know what they were going to make him do to himself. And then he marched up to his bedroom, slammed the door. They were all afraid that he was going to kill himself. So they got out of the house. They called in. So we had the elements we needed for a Baker Act. He was taken to the hospital. However, he was discharged almost immediately because he got his act together. The doctor had no further indication that he was a risk of suicide. But we were called. So our threat response unit was called, and we looked, and there was a 5-year history of this man terrorizing his wife and his children with situations just like this. And this was the biggest escalation so far. There were at one point, his wife had tried to divorce, but rescinded the divorce paperwork. There were multiple attempts at getting domestic violence protection orders. We learned that every time she got an order, he would restrict all of her access to finances and basically ice her out of access to any of their money until she dropped her order and agreed to move back in. So we had this situation where it was back and forth, and she did not feel safe to take any further action at this point because she was afraid that he would kill her. We took the initial step of filing the extreme risk protection order based on the suicidal threats incident and his long history of domestic and emotional abuse toward his wife. And there were some incidents of physical abuse as well. We got the order, and the woman, his wife, was able to get her and her daughters out of the house. She was able to move them out. She finally felt safe to do that. She filed divorce paperwork. She filed the domestic violence protection orders that she needed. She got a job, and she finally got away from him. And about a year later, I had already filed my retirement paperwork. I hadn't worked a case in about 6 months. I had to take my son to the dentist's office because he cracked a tooth. And when I called in, it was a different dentist than we normally go to because our dentist was closed for the holidays. So I get a call, I call in, and this woman on the phone is very nice. And she says, we'll get you in. Can I get your name and your information? I give her my name and information. And I notice a change in the tone of her voice. Oh, yes, Mr. Carita, we're going to get you in there right away, Mr. Carita. She's very sweet. I didn't think anything of it at the time. I get to the dentist's office with my son, and there's a very nice woman behind the counter. It's the woman I had spoken to on the phone. She greets my son, August. She's very, very kind to him. He's 8 years old. He's got a cracked tooth. He's upset. She's amazing to him. And then as she gives me my paperwork to fill out, she just says to me, "Small world, isn't it, Detective Carita?" And I got goosebumps on the back of my head. It was the woman that had been married to this maniac for 5 years. As I got back to the waiting room and it clicked who she was, I didn't recognize her. She had put on weight, healthy weight. She was healthy. She was happy. She was working. She was well taken care of. She was a different human being. And when I went back out and talked to her, I gave her a big hug. She thanked me, gave me an update on herself and her kids, and could not make enough about the fact that we had taken the extra step to intercede and to make sure she was safe to do what she needed to do to make herself and her kids safe. So I point this out because very often when we talk about domestic violence cases, we talk about the fact that, well, the victim can go get their own order, or there are other things in place that do the same thing as ERPO. They don't. It is different. It is different when law enforcement takes the initial step of creating that baseline of safety. And we have an opportunity in these situations to create time and space so that the victims of domestic violence can then take the next steps that they need to take to make themselves and their families whole again. So another case example, we have school shooting threats. These are really difficult, and it's important to know your state's specific ERPO statute when it comes to these cases, and we'll talk about why in just a second. So with these situations, you have concerning verbal or written expressions indicating potential violence, right? Posts online. You may have leakage where the subject is telling friends or friends or loved ones that they're thinking about violence. They may start making inappropriate jokes about bringing a firearm to school. They may have access to family-owned firearms, and this is where your statute becomes really important. You may also see behavioral changes or fixation on violent incidents. So why is ERPO so important in these situations? Well, more often than not, these precursor behaviors, these threatening behaviors that lead up to a shooting, to a school shooting, aren't enough for an arrest in most states. Veiled threats, if-then threats, if this happens, then I'll do this. Those in most states do not meet statutory guidelines for an arrest. In fact, most of those statements may even be protected speech. You also, very often in these cases, don't have enough for a mental health hold. And this also becomes extremely problematic when you don't have parents that are cooperative or willing to work with you to mitigate the risks that you're seeing. So why does IRPA work here? Well, it allows for firearm intervention based on substantial, credible risk identified through your threat assessment, through your investigation, right? So if you have observable behaviors that meet the criteria of your IRPO statute, then you still have an opportunity to at least remove firearms from the situation. Now, going back to what I said about knowing your state statute, it's incredibly important that you know your state statute because depending on how it's written, whether it states that an IRPO is to prevent access to firearms or is it possession and control, these words matter. And they matter because that's going to help you determine who has to be the subject of the petition. In the state of Florida, our statute states that an IRPO prevents access to firearms, which means that if a juvenile is the subject of an extreme risk protection order, the parent has an obligation to lock up and safeguard those firearms, or we can temporarily remove them until they've demonstrated that they can keep them safe and out of the possession of the juvenile. In other states, it's more strict in that if you're not the one in possession or control, in other words, you have to be the owner of essentially you have to be the owner of the firearm to be the subject of the order, then you may have to articulate why the parent is now the subject of the order. In other words, in order to remove those firearms from a situation where the juvenile may be able to get possession of them. So again, these are discussions you and your team should have ahead of time. You and your agency should have ahead of time. These are workable problems, but you should have a plan and have an understanding about how you would make these decisions before these cases come up. And then finally, you have situations of community violence. This has also been a hot button topic for us in law enforcement because we have a mindset that if somebody is engaged in criminal behavior, then we should be engaging in a criminal investigation and seeking charges. And that's correct. That those laws and that system is in place for a reason. However, very often you're going to have all the same indications that you would have with a mass shooting or suicidal threats. You're going to have the same escalating risk behavior that is articulated right there in the statute, right there in the IRPO statute, when it's two rival groups that are threatening one another and threatening retaliation with one another. You may have an example where somebody's brother got beat to shit at the local bar, and now the other brother is threatening to get his firearm and go down to the bar and take care of the guys who beat up his brother. That's a pretty reasonable response. The person's not mentally ill, they're angry, but they're not mentally ill, they're legally in possession of firearms, they're going looking for trouble, and we have two options. We could post up at the bar and wait for him to show up with a firearm and hopefully intervene after he's committed a violation, or we could intervene early. If he's making threats that he is going to show up with a firearm and take and exact revenge, we have an opportunity there to articulate that to a judge and to get a risk protection order. And what's important to understand also is that temporary order does not have to result in a final order. In that situation where we have an otherwise law-abiding citizen, no criminal history, but right now he is angry, he is armed, and he is determined to go exact revenge on the people that hurt his family, we can get the IRPO, we can get the temporary order, we can temporarily remove firearms, we get our violent crimes unit to work their butt off and finish that case and make the arrests we need to make in the next couple weeks. And then by the time the final hearing comes around 2 weeks later, we can say to the judge, hey, we've mitigated the problem. We have no other reason to think that this person is a danger to themselves or others. We've had discussions since then. He is happy with the results of our criminal investigation and feels no reason to go forward, and we're okay with dropping the order. Keep in mind that IRPO is always an extra tool that can be there to fill the gaps, create safety when your normal procedures, your normal criminal procedures, your normal mental health holds don't do the job of getting the firearm out of that situation temporarily. So what have we kind of gone over today? We've talked about some high level examples of when it can be applied and how it can fill the gaps in the real situations that we face as law enforcement. We talked about applying ERPO, how applying ERPO well requires policy, practice, and procedure. And we're going to talk a little bit now about some of the more in-depth scenario-based training that 97% offers as you want to train yourself, your agency, and bring greater knowledge and effectiveness in using this tool in your community. So again, as we said at the beginning, 97% has been offering more in-depth training on extreme risk protection orders. What we have found is that after these laws pass, most states don't have the funding or the infrastructure to put out comprehensive training. We're trying to fill that gap and also work with states to build their capacity. So the first class that we offer through 97% is a full day ERPO Essentials for Law Enforcement course. In that course, we go over ERPO terminology, statutory elements, and timelines. We talk about the specific behaviors and identifying those behaviors and indicators that suggest an ERPO may be needed. So this is great for your first ones on scene, your patrol officers, and really for everyone in your agency as a baseline for your ERPO knowledge and when and how to apply it. We talk about conducting your investigation and focusing on prevention, not enforcement. But we also talk about balancing Miranda considerations when a search warrant is still appropriate or needed, and how to make sure that we are respecting all the rights that this person has as far as if we need to conduct a criminal investigation. How do you balance your ERPO investigation along with your criminal investigation? How do you make sure that you're not overstepping and using an ERPO to circumvent the need for a warrant? Things of that nature. We also talk briefly about writing complete petitions, safe service and firearm removal, and then planning for follow-up and renewal in the long term. Then we offer another one-day course. This is more for the folks in your agency who are likely to be the ones writing the petition. In some smaller agencies, that's going to be everybody. Everyone needs to have a working knowledge of how to write the petition. But most agencies we're seeing ends up dedicating one person or a team of detectives or investigators to adopt these cases as an ERPO is necessary, and they're the ones writing the majority of the petitions. So during this workshop, we go over how to write an effective ERPO petition to meet your legal standards that are required by your state statute, how to connect those observable behaviors to statutory language, just like we do with our probable cause affidavits. We talk about writing clear chronological narratives in plain language, right? When you write your petition, you're not giving bullets of, I saw this, I saw this, I saw this. You need to learn how to write a clear chronological narrative to make it clear to the court and to make it clear to the public why you took this action and why you're seeking an ERPO. You're going to work through, during that course, we're also going to work through a real case study. We're going to use body cam video from a real case to actually point out the behaviors and identify those and then work them into an actual complete petition based on all of the evidence presented by a real case. Then we have a 3-day ERPO and behavioral threat assessment for law enforcement and public safety. During that course, we're going to discuss how to investigate threats using a behavioral threat assessment and management model. We're going to connect the behavioral threat assessment and management elements to the ERPO statutory framework to strengthen petitions and to strengthen our ability to speak in court. We're going to apply that BTAM framework to build sound safety plans for ERPO service, prioritizing de-escalation and earning compliance. What does that mean? That means once you've done your full assessment and you've applied this behavioral threat assessment framework, you're going to know pretty confidently what you need in the way of resources when you go back to this home, when you serve the order. Is this someone who's been compliant, who has been cooperative, and who has been receptive to change, receptive to accepting help? Then this is somebody that we probably don't need to call out a tactical team to assist us on service. This is someone who we can probably go with our partner and continue with that line of compliance. The flip side is if we have someone who is contentious and dangerous and has demonstrated that they have no interest in cooperating with us, we want to make sure that we have the personnel on hand necessary to keep us safe when we serve these orders. Also, this course is going to help build a foundation for all threat investigations, and it's going to improve officer safety, increase cooperative outcomes with the subjects. We're going to gain compliance. We're going to reduce bias in decision making, and we're going to help limit liability for investigators and their agencies by having a consistent framework by which you make your decisions about how you manage these cases. Also important in this case is there are going to be plenty of cases where you have a real threat, a real concern, a person who means to do real harm, and an ERPO is not appropriate. And in this course, we talk about what other avenues and what other tools are available, both for you as law enforcement and amongst your partners in your community that you can leverage to help manage these cases. And then finally, this is something that we've pioneered, and we're working with different states to implement. So we're offering a 5-day ERPO Train the Trainer course. So during that 5-day course, those who complete the course are going to be certified to teach this 60 to 90-minute class. They're going to be certified to teach the 1-day essentials for law enforcement to their agency and to other agencies in their state. And they're going to be certified to do the 1-day petition writing workshop. Along with that, the Train the Trainer course is going to teach them to develop ERPO cases from your own agency or your own state into case studies that you'll incorporate into your training to make sure that the training speaks to your audience and that it makes sense for the folks who are doing this work on the ground. You're also going to learn how to tailor the training to the statutory and cultural context of your state or your jurisdiction. What does that mean? Well, if I'm an officer in New York City and my job is to execute extreme risk protection orders for the NYPD, the culture in New York City around firearms is very different than rural Minnesota, who may have a strong gun culture, a strong hunting culture. They may have large pockets of a veteran population who have a very different perspective on gun ownership and how that factors into who they are and their capability as a citizen. Understanding your community and working that into your training so that your officers are respectful of the beliefs and the feelings of and the dignity of the community that they police is extremely important. And that's something that we cover during this 5-day training. And then finally, we've started doing more agency and state-specific ERPO policy workshops. So we work directly with agencies, state coalitions, and cross-disciplinary teams to create a comprehensive agency and state-specific ERPO policy. We develop or update statewide or agency-specific ERPO policies and procedures, and then we align those procedures with statutory requirements. We ensure due process protections are respected. We talk about the local ecosystem, again, respecting that ERPO can and should look different and be and may solve different problems in different communities. And then we continue to support that implementation through follow-up training and additional technical assistance. So with that, I want to thank you all for your time. We are going to go off camera in just a moment, and I'd like to open it up for questions to anybody who has any. You're also welcome to post them in the chat, and I can go through them in the chat as well if that's more comfortable. But again, my name is Christopher Carita. This is my cell phone number. 2 a.m. we're not friends anymore. 2 p.m. all good. That's my direct email. And if you want to learn a little more about 97%, that's the website for the organization. And also, we're going to be relaunching our training website in the coming months, so I'll keep you up to date on that as we offer that training ourselves, and we also look to partner with agencies and states to offer the broader programs. So with that, let me pull us off camera.